errors by a servicer, the process for requesting information from a servicer, and requests for payoff statements. I don't know that we'll get into each one of those in great detail. Sorry, my apologies for the issues here with the presentation. Okay, so first let's talk about some general stuff about the new rules. First of all, they were adopted in January of 2013 pursuant to the Dodd-Frank Wall Street Reform and Consumer Protection Act. And then we've issued various amendments to the rules, which you can see on the CFPB's website. The new rules became effective just a couple of weeks ago on January 10th, 2014. And the rules have very specific requirements, a lot of which we'll talk about today. But then there's also a general rule that requires servicers to adopt policies and procedures that are reasonably designed to achieve objectives relating to these following things. So again, these aren't like specific rules. These are just policies and procedures with these objectives in mind. So that includes accessing and providing timely and accurate information, properly evaluating loss mitigation applications, facilitating oversight of and ensuring compliance with the rules by service providers, facilitating transfer of information when servicing is transferred, informing borrowers of their error resolution and information request rights, and then there are rules on record retention and what should be in a servicing file. We thought that that particular section of this regulation was important enough that you should all have a copy, so that's an appendix to the guide itself, and it's 102.4.38 of the regulations, and you'll see that at the back of the regulations. I'm sorry, at the back of the guide. There's an exemption for small servicers. A small servicer is defined as a servicer that, together with affiliates, services 5,000 or fewer mortgage loans, or services, and services only mortgage loans that they or an affiliate originated or own. So that's going to be, again, a small servicer, and they have to only be servicing a loan that they own. And housing finance agencies are also small servicers. Servicers aren't exempt from everything. They're exempt from some of the requirements of the rules, and there's a chart, which is Appendix B to the guide, that tells you which rules servicers have to, small servicers have to comply with and which ones they do not have to comply with. Okay, so applying for loss mitigation. Yes?
So Kathy, before you move to the next section, I just want to add here that even though we're going to be going into the weeds on the CFPB's new mortgage rules today, remember that servicers also have to comply with whatever guidelines that the investor or owner of the loan has issued, also the insurer. So, for example, your FHA, VA, RHS, those rules are still in place, and servicers do have to abide by those as well. So just wanted to point that out. This becomes important when we talk about issues that are not really fully covered by the CFPB rules, like what, for example, is a complete workout package. Investor guidelines and insurer guidelines issued by Fannie Freddie, guidelines under HAMP, guidelines under the National Mortgage Settlement, for example, all deal with what is considered a complete application.
Absolutely right. Thanks, Odette. And I'm going to talk about this in a couple slides, but just to sort of add on to that, our rules set forth a process requirement. In other words, these are the process requirements that a servicer has to abide by if they offer loss mitigation options. In terms of like what they have to offer and how what's a complete application, that's all going to be driven by the other things that Odette referred to. Okay, so just moving back to the slides. So one thing we want you to tell your borrowers you're working with is take the call. We know that borrowers tend to maybe try to avoid calls from creditors when they're behind on an obligation. But the rules are specifically set up to encourage borrowers to work with their servicers and to require servicers to work with the borrowers. So we want to make sure borrowers take advantage of those rules. The other is that a borrower does not have to be delinquent to apply for loss mitigation under these rules. Some of the rules, like the early intervention rules, we'll talk about those, only apply to delinquent borrowers. But a borrower can apply for loss mitigation under that process, even if they're not delinquent. So, for example, if they know they're going to have trouble making next month's payment, that borrower may want to initiate the loss mitigation process with the servicer before they even miss a payment. The rules provide a servicer is only required to comply with the requirements for the loss mitigation process for a single complete loss mitigation application for a borrower's mortgage loan account. So that means if a borrower submits a complete loss mitigation application and later seeks additional assistance, the borrower may not be entitled to a second full loss mitigation process under the rules. But if the servicing is transferred to a new servicer, that may present an opportunity for the borrower to apply for loss mitigation again. Small servicers are exempt from most of this loss mitigation process, except that they have to comply with the 120-day foreclosure prohibition, which we'll talk about in full in a little bit. They also cannot essentially file for foreclosure or go forth to a judgment or order of sale if the borrower is performing pursuant to the terms of an agreement on a loss mitigation. So that applies to both small servicers, those two things, and to the non-small servicers, but the other loss mitigation rules don't apply to small servicers.
And Kathy,
yes, I'm sorry, go ahead.
The CFPB also mentioned in their summary that substantially all community banks and credit unions would fall under the small servicer category.
Yeah, as long as they meet the definition, they would, yes. And then this is what I was just talking about. So these rules are process rules. In other words, they have to be followed by a servicer who offers a loss mitigation option to borrowers, but the owner or the assignee of a loan, or as Odette said, if it's an FHA loan and there are rules there, they get to determine what options will be available to the borrower. Okay, so first of all, the first thing I think any advocate has to do to assist a borrower under these rules is identify what I've called here key dates. Some of the timing under the rules runs from the date of delinquency forward, and some of the timing under the rules runs from the date of a foreclosure sale and how many days it is before the foreclosure sale. So that means that you may not know all of these when a borrower comes to you for help, but this slide shows you the various deadlines that are somewhere in the rule, and so the dates that you should try to identify as you're analyzing a case for the first time. And then, of course, this is going to be like a dynamic document that you're going to be able to fill dates in as things move forward. But you have to know the date of delinquency, and then 36, 45, and 120 days after that. And then once you know the date of a foreclosure sale, you have to identify 37, 45, and 90 days before the foreclosure sale. Then you want to know when the servicer received a complete loss mitigation application and the date the servicer provided the borrower with a loss mitigation offer. So those are all things that I would have, like in each file to identify so that you can assist the borrower knowing what rights and responsibilities they have depending on the deadlines. Okay, I accidentally just added a slide. Sorry about that. There's no deadline for completing a loss mitigation application, but the earlier your clients get their complete loss mitigation applications in, the better. And you should also take note that the rules became effective on January 10th, 2014. And so any borrower who files a complete loss mitigation application on or after that date and more than 37 days before a foreclosure sale is entitled to an evaluation of their complete loss mitigation application for all available loss mitigation options. So there's some other conditions in 102.4.41, which is the loss mitigation rule. I'll talk about them later. But the important point here is that if you have a client who has been rejected before or filed before or been granted a loss mitigation before January 10th, that application would not have been handled under the new rules. And so the borrower is going to be able to get a new bite at the apple under the new rules. The definition of delinquency for purposes of some of these rules, early intervention and the continuity of contact rule, is whenever the borrower doesn't make a payment which is sufficient to cover principal, interest, and if the borrower is paying in with the payment, escrow and insurance, taxes and insurance into escrow. That's true even if the arrangement gives the borrower a grace period. So if a borrower has a 5-day grace period without getting any sort of fee or anything, it doesn't matter. If they don't get that full payment in on the day the mortgage payment is due, they're considered delinquent for purposes of the rule. In terms of how you count days for purposes of how you count days, for purposes of figuring out when the servicer has to do the stuff that's required that we're going to talk about in a minute, basically the day after the incomplete payment or the missed payment is day 1, so that if a borrower's payment is due on January 1st, January 2nd is day 1 for purposes of counting how many days out you are for the other rules. Okay, so what is the loss mitigation process? So what we've done here is divide it up into steps in the order that they would be experienced by the borrower. So the first thing that should happen under the new rules that's required to happen is between the day of the borrower's delinquency, when their mortgage payment is due and not paid in full, and 36 days later, the servicer has to make a good faith effort to reach the borrower or an authorized agent of the borrower by telephone or talk to the borrower in an in-person meeting. So this is the live contact requirement, and again, that has to happen between the day of the delinquency and 36 days later. There are a few exceptions. The one that is the most notable, and again, the exceptions are all spelled out in the guide, but the most notable one is if the borrower has sent a do not contact letter under the Fair Debt Collection Practices Act to the servicer does not have to comply with this 36-day requirement. So we suggest that you might consider having borrowers rescind a cease communication instruction under the Fair Debt Collection Practices Act, because if they don't do that, they're not going to get the benefit of all this early intervention contact from the servicer. And of course, the early intervention contact from the servicer is meant to see if there's a way to work out a way for the borrower to stay in the home. The next thing that happens is just promptly after the servicer makes that initial live contact, the servicer has to tell the borrower or the borrower's agent about the availability of loss mitigation options if it's appropriate to the situation. So obviously if you get someone who just calls and says they're going to be late, they aren't necessarily going to get this contact, but under other circumstances, they likely would. This doesn't have to be specific about workout options, but it can just generally be about what loss mitigation options might be available. And then it's within the servicer's reasonable discretion to decide if it's appropriate under the circumstances to inform the borrower about the availability of loss mitigation options. And here's a couple examples from the commentary. If the borrower's had a material adverse change in the borrower's financial circumstances that's likely to cause the borrower to experience a long-term delinquency, then the servicer should tell the borrower about the options. But if the borrower simply says the payment will be late, the servicer doesn't have to inform the borrower about loss mitigation options. Again, the exception of this, and I'm sorry, go ahead.
No, I just wanted folks to know material adverse change, because that's kind of legal lingo. You know, obviously things that hardships like unemployment, death of a co-owner, stuff like that would be a material substantive change in their circumstance. Yep.
Again, I'm going to start speeding through this slide because it's the same thing, but the exception to this requirement, again, is the FDCPA, the Fair Debt Collection Practices Act, so consider having your borrower rescind that. Okay, the next thing that happens is the servicer has to assign personnel and send a written notice. The timing on this is between the day of the borrower's missed mortgage payment and 45 days later. So first we're going to talk about assigning personnel. So this is meant to provide continuity of contact between the servicer and the borrower. The servicer is required to maintain policies and procedures reasonably designed to ensure that the servicer can assign personnel to the delinquent borrower who will be available via telephone immediately or in a timely manner. This doesn't necessarily have to be one person. It can be a group of people, but it's a dedicated team that's for this borrower and for this borrower's account. They have to have access to all documents and information the borrower submits with a loss mitigation application. They have to facilitate the sharing of accurate and current information and the status of foreclosure proceedings between the assigned personnel, and they have to be able to ensure sharing that information with other appropriate personnel, for example, an attorney handling foreclosure on the case. Those people are also personnel are supposed to be able to respond to the borrower's inquiries. They're supposed to be able to help the borrower with loss mitigation options by giving the borrower accurate information, telling the borrower what they have to do to apply, telling the borrower what the deadlines are for applying, telling the borrower how to appeal if there's a denial, telling the borrower the status of any pending loss mitigation application, being able to retrieve and provide information to anyone considering the borrower for loss mitigation, give them a complete record of the borrower's payment history, and being able to retrieve and provide anyone considering the borrower for loss mitigation all information the borrower has submitted. And also they're supposed to be able to give the borrower information about error resolution. The personnel assigned have to stay on this case, on the borrower's servicing file, until the borrower has made 2 consecutive mortgage payments under a permanent loss mitigation plan. So the same personnel should be dealing with the borrower over the course of that time period. There's a few exceptions. You can see those in the guide. The other thing that happens within that first 45 days, so we've got first the 36-day live contact, then we've got that follow-up general information. Then at the 45-day mark, by then there should be the personnel assigned, and then also between the day of the borrower's missed mortgage payment and 45 days later, the servicer is supposed to send a written notice to the borrower, and the notice has to have the following things. Basically encouraging the borrower to contact the servicer, giving them a phone number, giving them a loss mitigation application if applicable, and giving them your phone number if you're a HUD counselor. So this is meant to basically, in writing, again, encourage the borrower to get some help and to, if possible, contact the servicer to talk about what options are available. There's a few exceptions. It's the same one, Fair Debt Collection Practices Act exceptions. So again, your borrower won't get the advantage of this contact if they've sent a do not contact letter under the Fair Debt Collection Practices Act. Okay, the next thing that happens in this timeline, so we now have 36 days, we have that initial contact, we have the follow-up afterwards, we have personnel assigned, we have the written notice within 45 days. The next thing that's going to happen is the borrower is going to get something under a completely separate rule, and that is that there's a new periodic statement rule. This rule applies to borrowers who are and are not delinquent. It basically says that the servicer has to send a monthly periodic statement to most borrowers, but there's an exception if the servicer sends a coupon book. In any event, once the borrower is delinquent, the periodic statement rule requires the servicer or mortgage owner to send the borrower certain information. It has to be grouped together. It can either be on a periodic statement or on a separate page enclosed with a periodic statement or in a separate letter. And this information on this particular communication is going to include some of the same stuff plus the date the borrower became delinquent. There has to be an account history, which covers the period since the account was last current or for the last 6 months, whichever is shorter. And then also showing for that period the amount past due from each billing cycle, the date that the payments were credited as fully paid. It has to tell the borrower whether a foreclosure has been started. It has to tell the borrower how much they have to pay to bring the account current. And again, it's going to give access to the HUD housing counselor list. There's a sample form for that. Go ahead.
And no, I just wanted to note that this is actually a very valuable piece of document, and if you are working with homeowners, if you could have them bring that in, because there's certain key information. Of course, you could figure out the date of delinquency, but you could verify it by looking at this document. And most notably, whether the foreclosure process has started. That's important when we talk about dual tracking and other issues later.
Absolutely. And if they've been receiving periodic statements to the extent they've kept them, that's also a very good source for information. Again, exception to this rule, Fair Debt Collection Practices Act. I won't beat that horse again. Okay, so now we've had all this contact that the rule requires the servicer to make with the borrower in the hopes that the borrower will pick up the baton and run with it. The next thing that we expect to happen and we want to happen is we want the borrower to apply for loss mitigation. So first I'm going to tell you that I'm going to talk about 3 different terms in this next few slides, and I want you to keep them separated. One is just an application. The other is a complete application. And the third is something called a facially complete application. There are 3 different things, so I just want to call your attention to which one I'm talking about. And the reason it's important is once there's an application, it triggers certain responsibilities by the servicer. Okay, so the first thing to do is to determine when a borrower has applied for loss mitigation. And again, that's crucial because the servicer will have obligations after that. Okay, so what's an application? An inquiry about loss mitigation in which the borrower provides nothing to the servicer, no information, just a call saying, I'd like some information about loss mitigation. That is not an application. But if the borrower provides any information that would be evaluated as part of a loss mitigation application, providing that information is an application. So the commentary gives an example of communications from the borrower to the servicer that would be considered an application and says that a loss mitigation application is considered expansively. So you can take a look at those. But for example, if a servicer would take income information as part of a loss mitigation application, and the borrower calls and says, I'm going to miss my payment next month because I've just lost my job, and I'm going to have no income last month, that's probably an application. And Odette, do you have a comment on that at all? Or?
Yeah, you hit it on the ball. It can be a verbal and oral application. We often think of everything has to be in writing, but it can be oral, so that's important to know.
Right. This is an important one. If servicing on a mortgage account is transferred to a new servicer, documents and information transferred from the old servicer to the new servicer may count as an application for loss mitigation. So it doesn't even necessarily have to come from the borrower. It may be in the course of transmitting this during a transfer. Okay, so what happens next? So now the borrower has applied. What happens next? Well, first of all, in general, the servicers have to maintain policies and procedures reasonably designed to ensure that the servicer can identify documents and information the borrower is required to submit to complete a loss mitigation application. And then this is where the first, like, why you should apply early rule comes in. This rule that I'm about to describe to you, it applies only if the application is received 45 days or more before a scheduled foreclosure sale. So this is a very important rule I'm going to talk about, and this is why we want those applications in 45 days or more before a scheduled foreclosure sale. If it comes in during that time, the servicer has to promptly review the loss mitigation application to determine if it's complete, then send the borrower a written acknowledgement that the servicer received the application, tell the borrower whether the application is complete, and they have to send this written notification within 5 days after they receive the application, not including weekends and legal public holidays. And if the application is incomplete, the servicer has to tell the borrower what additional documents and information have to be submitted to complete the application. The servicer also has to give the borrower a reasonable date by which the application should be completed. So this is an incredibly crucial rule because basically as a housing counselor or advocate, you're going to have a document from the servicer that says these are the 5 documents and the 2 pieces of information, and I use that by way of example, that the borrower has to give to us to complete the application. So now you have direct communication about what will complete this application. And then the servicer also has to exercise reasonable diligence in getting the documents and information to complete the application. So for example, the commentary gives us an example of this. Contacting a borrower for a missing employer address to verify employment, checking for missing information in the file transferred to the current servicer by a former servicer, and that sort of thing. And then this is the difference. If the application is received less than 45 days before a foreclosure sale, the servicer is not required to provide that written acknowledgement. And there's still a responsibility by the servicer to exercise reasonable diligence to complete the file, but the borrower's not going to get that writing that says, here's what you need to complete the file. Okay, so now we've got an application. The next thing that has to happen is the borrower has to complete the loss mitigation application. So the borrower has to provide the servicer with a complete loss mitigation application in order to be evaluated for programs. So just having applied is not enough. There has to be that completion of the application. Again, there's no deadline for completing a loss mitigation application, but the sooner it happens, the better for the borrower. An application is complete when the borrower gives the servicer all the information it requires from the borrower. So if the servicer is waiting for information from somebody else, from a third party, like a credit reporting agency or an employer, the application is still complete once the borrower submits everything required from the borrower to be sent to the servicer. And the servicer can establish its own complete application requirements, but again, as Odette pointed out, that may be dictated by the investors in the loan. It may be dictated by FHA rules or something like that.
Or if they signed on to a settlement, that it may be dictated by that as well.
Okay, so now we get a complete loss mitigation application in. So the borrower has applied. Hopefully they've done it before 45 days before the foreclosure sale, which means they will have gotten this writing saying, here you are, this is what you need to complete your application. So what happens once there's a complete application? Well, again, it depends how close to the foreclosure sale the complete application is received. If the complete application is received more than 37 days before any scheduled foreclosure sale, or if there's no foreclosure sale scheduled at all, the application has to be evaluated for all loss mitigation options available to the borrower. And again, any borrower who files a complete loss mitigation application on or after January 10th gets the benefit of these new rules. The evaluation of the complete loss mitigation application has to be conducted by the servicer within 30 days of the servicer receiving the complete loss mitigation application. What happens if the borrower submits or completes the loss mitigation application 37 days or less before a foreclosure sale? The servicer does not have to follow the rules requirements on evaluating the application. So the investors may have rules that require an evaluation that is with an application that comes in that shorter time frame, but the rules do not. So you want to make sure your borrowers complete their loss mitigation application more than 37 days before a scheduled foreclosure sale. There's some rules on transferring servicing that are really important. If servicing is transferred while the borrower's complete loss mitigation application is being evaluated, the transferee servicer has to get all the documents that the borrower gave to the old servicer, and if the documents constitute a complete loss mitigation application for the new servicer, the servicer has to pick up the ball. They have to continue with the evaluation. And they're treated that if the documents are treated as if they were submitted on the date they went to the old servicer. Okay, then there's this animal under the new rules called a facially complete application. So remember we talked about if a borrower gets an application in 45 days or more before a foreclosure sale, they're going to get this writing that says, you, borrower, have to submit the following documents and the following information to complete your application. And then let's say the borrower actually does submit those things, whatever was requested by the servicer in that 45-day letter. If the borrower has submitted all that information requested, or if the letter did not request any additional information, and if the servicer later determines they need more stuff, they need additional information or corrected documentation to complete the application, then the application is considered facially complete. And what that means is this. If an application is facially complete, the servicer has to promptly request the missing information or corrected documents. The servicer has to treat the application as though it was complete for purposes of the foreclosure protections, and we'll get into those a little later, but basically once that letter goes out and the borrower facially completes their application, the servicer is not going to be able to file for or continue with a foreclosure until there's a reasonable opportunity to complete the application and there's a resolution of the application. There's a decision on the application.
So the bottom line
again,
is that they shouldn't be giving you the runaround on these documents. Once they have in writing that this is what's needed to complete the application, you complete it. They shouldn't be giving you the runaround.
Absolutely. And if the borrower goes, and it's not that they're not allowed to ask for the additional stuff, but the borrower gets all the protections they would get once they've completed it as instructed in that first 45-day letter. The borrower still will need to send in additional stuff as long as it's reasonable. And once they do that, once they get the rest of the information that's requested in, the foreclosure protections continue. The application is considered complete as of the date it's facially complete for purposes of the protections for the borrower, but the evaluation by the servicer won't start until the date that the application is complete with the new information. Okay, and then, you know, we didn't want servicers evading these rules by evaluating incomplete applications. So except for two small situations, which you can look at on page 35 and 36, the servicer cannot evade its obligations to evaluate a complete loss mitigation application by offering something based on an evaluation of an incomplete application. Okay, so next, what's going to happen is now that we've got a complete application, the servicer is going to either offer or deny a loss mitigation option. The servicer has to do that within 30 days in a written notice. The content of that notice is going to depend on whether an offer is made or not. If an offer is made to the borrower, the servicer has to put in the written notice what's being offered, tell the borrower how long they have to accept or reject the offer, and if it's a non-home retention option like a short sale or something, Hello?
You're back.
I can hear you, Kathy.
Yeah.
Okay, I'm sorry. I got a weird, yeah, okay. So an offer that involves non-home retention like a short sale can be conditioned on receipt of further information, but otherwise not. Okay, if an application is denied, the rule that I'm about to talk about only applies to a denial for a loan modification program, not for other loss mitigation options. The written notice has to give specific reasons for the denial for any loan modification program, whether it's a trial program or a permanent program. And the reason has to be fairly specific. It's not enough for the servicer to say the denial is based on an investor requirement. The servicer has to identify what the investor requirement is. And if the permanent loan modification or trial modification is denied because of a net present value calculation, the servicer has to provide the borrower with the inputs were used. So it's not enough to just say we ran a net present value calculation and you didn't qualify. The servicer has to tell the borrower of any rights. I'm sorry, go ahead, Odette.
No, I just wanted to add here that if they were considered for more than one loan modification option, sometimes they're considered for proprietary and another program, you have to give, for any modification program that they're considered for, you have to give an explanation why they were denied.
Yep. That's absolutely right. Okay, and then the servicer has to notify the borrower of any rights to appeal. Okay, let's talk about accepting or rejecting an offer. Let's say the servicer decides to offer a loss mitigation option. The servicer has to give the borrower a deadline by which to accept or reject the offer, and the timing on that deadline is going to depend on when the complete application was received. If the completed application was received 90 days or more before the foreclosure sale, then the servicer has to give the borrower at least 14 days to accept or reject. If the loss mitigation application was completed between 90 and more than 37 days before the foreclosure sale, the borrower gets at least 7 days to respond. Okay, and I'm going to go a little bit faster through here. If the borrower doesn't respond, the borrower is probably going to be treated as rejecting the offer unless they start making payments under the plan. If there's a denial for a loan modification, there is a right to appeal, but only if the servicer received the complete loss mitigation application 90 days or more before a foreclosure sale. So in a perfect world, to give borrowers the most rights of appeal, et cetera, the complete loss mitigation application should be done 90 days before a foreclosure sale. There's no appeal for any other denial, so it's only for a denial of a loan modification. The appeal has to be taken within 14 days after the servicer provides the denial, and the appeal has to be conducted by people who were not involved in the decision in the first instance. The servicer has 30 days after the appeal is made to decide what to do with the appeal, and there's no further appeal right after that. And it's important to remember, and Odette, maybe you want to say something about this, that borrowers have a private right of action to enforce the rules on the loss mitigation rules under the Real Estate Settlement Procedures Act. Do you want to comment on that briefly?
Oh, absolutely. So you've seen throughout the slides several references to 1024.41, and it gives the consumer the right to hire an attorney and to enforce any violations of the servicing rules, and that is important, especially important because under many other types of programs, under the settlement, like the National Mortgage Settlement, for example, we don't have that, or consumers don't have that right to enforce the various violations.
Okay, so the next topic we're going to talk about is foreclosure prohibitions, and this is a shorter one, you'll be happy to know, but important nevertheless. And then I think after this section we're going to pause for some questions. First of all, we have to talk about what does it mean to file a foreclosure. So, you know, the CFPB is a federal agency writing federal rules, and of course how you start a foreclosure is a matter of state law. So we have a relatively long definition so that we all are on the same page that we're talking about starting the foreclosure legal process, however that's done in your particular state. I'm going to talk about the word file or filed right now to represent that, but just take a look at how it's defined in the rules if you're not sure about what that means. Okay, so what are the prohibitions on filing a foreclosure, starting the legal foreclosure process? Well, first of all, there is a flat-out 120-day prohibition. No servicer, including small servicers, can file for a judicial or non-judicial foreclosure during the first 120 days the borrower is delinquent. There's two teeny-tiny exceptions that are probably, they're on the slide, they're in the guide, but they're not even really worth mentioning. You've noticed that while we've talked about the other stuff, the loss mitigation process, we've said the ideal thing is to get a complete loss mitigation application in 90 days or more before a foreclosure sale. This rule gives everybody 120 days to get through that loss mitigation process before a foreclosure can be initiated. A servicer also cannot file for foreclosure if the borrower submits a complete loss mitigation application before the foreclosure is filed. So even if you're past 120 days, if the foreclosure has not been filed yet and the borrower submits a complete loss mitigation application, there cannot be a filing of the foreclosure until one of these three things happen. One is the servicer has denied the borrower's application and the appeal process is either not available, or the time for appeal has expired, or it's been appealed and denied. The two is that the borrower has rejected all the loss mitigation offers, or three is the borrower is not performing as required under a loss mitigation agreement. So in other words, the servicer can't file as long as that completed loss mitigation application is still live and being ruled on, or is it under a performance of a loss mitigation plan. And then same thing, a servicer can't file for foreclosure at any time if the borrower is performing pursuant to a short-term payment forbearance program or to any loss mitigation agreement. So that's the prohibition on actually starting the foreclosure. Next, we're going to talk about what happens if the foreclosure is already going, and are there any prohibitions on proceeding with the foreclosure? And the answer is yes, there are. If the foreclosure has already been filed, and it's more than 37 days before a foreclosure sale, and the borrower submits a complete loss mitigation application, the servicer can't do the following thing. The servicer cannot move for a foreclosure judgment. That includes a dispositive motion. This is all kind of lawyerese, but like a motion for a default judgment or a judgment on the pleadings or a summary judgment. The servicer also can't move for an order of sale or conduct a foreclosure sale. And again, it's until the same three things happen. Basically, we get through the complete application process. Then this is the call off the lawyers paragraph. Once the servicer receives a complete loss mitigation application during this time period, the servicer has to promptly instruct any lawyers it's retained not to proceed with filing for a foreclosure judgment or an order of sale or conducting an order of sale. And if necessary, the servicer is to instruct the lawyer to file for a delay with respect to any deadlines for filing any dispositive motions. The servicer can continue otherwise litigating, arbitrating, mediating, etc., but they can't do the things that we've just mentioned. And if the servicer's already made a dispositive motion, they've already filed for summary judgment or something like that, and the borrower completes the loss mitigation application, the servicer has to take reasonable steps to avoid a ruling on that motion until the loss mitigation process is completed. So again, these are things, I'm sorry, let me just say one sentence. So these are things that both relate to starting the foreclosure and then also prohibitions once the borrower completes an application after the foreclosure has started. But again, that 37 days before a foreclosure sale is crucial. This stuff has to get in more than 37 days before a foreclosure sale. Okay, sorry, Odette, go ahead. Odette and I are in different locations, so we can't see each other.
No, and I just wanted to remind folks again that the reason, of course, these rules are important, not only because we want to stop the foreclosure process to give our clients time to do a proper workout, but because these rules are important because our clients can actually sue to enforce them as well. So we should be very mindful of keeping an eye on the time period.
So I think we're going to open the floor for some questions right now. Is that right?
That sounds good.
Okay, so give us just a second because we're going to get me on speaker instead of on, or at least we're going to try to get me on speaker instead of on a headset. So let's just take a 2-second pause here.
Great. And while we're pausing, a number of people have asked whether they can get a copy of the slideshow, and yes, we'll circulate that to people after the.
Actually, we're not releasing the slideshow. Not my call, but the guide.
Okay.
I will say I think you're better off with the guide than with the slideshow because in order to really help your clients, and I think Odette will back me up on this, you need to have the references to the rule itself.
Absolutely, and
the guide is much more complete.
And the guide closely tracks the slideshow, so I don't think anyone would
It's the same lingo, yeah.
Okay,
hang on, I'm going to get off for a second.
Sure.
So, so my mistake, we stand corrected, and so the guide will be the reference. They would send that link out again after the conference call, after the webinar. So Kathy, let us know when you're ready. You are ready? Good. So do the rules apply to FHA loans?
Can you hang on just a second? I'm not able to hear. Hold on a second. Sorry, hang on. We're having a technical problem.
Hey guys, Bruce, can you hear me?
I can hear you, yes.
Okay, so let me do a little more trick, another trick, but hang on one second.
Okay. All right, hi, sorry.
Okay, so do the rules apply to FHA loans?
Odette, you want to take that one?
Yes, they do. And the requirements under the FHA loss mitigation program overlay the rules. So, for example, the FHA program defines what is considered a complete application. It has further guidelines on the time the application must be submitted, but they do, yes, apply to FHA loans. Kathy, do you have anything to add on that?
Yeah, I mean, I would just say, you know, as long as the servicer who is servicing the loan is covered by, is under the definition of a servicer under RESPA. So, you know, if for some reason you had a small servicer servicing an FHA loan, they would have to abide by the small servicer rules. If for some reason you had FHA servicing their own loans or something, you know what I mean? Like, it's still the servicer has to be a servicer,
Right.
regardless of what kind of loan it is. So, yeah.
Right. That's a good point, Kathy. If FHA took assignment of the loan and was actually servicing their own loan, that wouldn't apply.
All right, hold on one more second. Here. Okay, sorry, we had to do a little switcheroo of the microphones. Can everybody hear me okay?
Yes. So
okay, great.
So if somebody has submitted a HAMP application, or the counselor submitted the HAMP application before 1/10/14, will the rules still apply to those cases?
I'm going to answer first, and then I'm curious to hear Odette's answer as well. So if the application process was started before January 10th, then your borrower is not going to get any of the benefits of the new rules. So you certainly, at the point where January 10th hit, to the extent you're in the middle of the process, you would, from that day forward, get the benefit of the rules. But you may want to consider just starting the process over again. So if you've been, for example, getting, you know, if the servicer's been telling your client constantly they need new information or different information, you may want to, and you're more than 45 days out from a foreclosure sale, if you get an application and you're going to get that writing saying, here's what we need to complete the application, and you may get the benefit of the facially complete rule. So I would say consider whether you want to start over or join the process somewhere in the middle if you're still having problems. Odette, do you want to take that one too?
Yeah, and I would actually agree with that. It depends on where your client is in the process. I mean, if it makes sense for them to start over, if they're not going to be, you know, if you're getting through and you're not having a lot of problems, it might not be worthwhile to start over. But if you're being frustrated and the servicer is giving you the runaround, then it might, you know, it's a cost-benefit analysis. It might make sense to start over from the beginning so you can get the acknowledgement letter, so you can get all the benefits, the full benefits of the rules.
And my suggestion would be, just as a practice point, you know, this is why we want people to have the larger guide, not the slideshow, is that if that's happening to you, then, you know, if you're going to contact the servicer on behalf of a client, you can say, we are making an application under, here's the site to the rule, and we expect to get it's more than 45 days, and so we expect to get a written acknowledgement under this section of the rule. And you should have no trouble finding the subsections in the guide because each sentence has a site.
And can you just repeat quickly where you could find the guide? We're getting a lot of questions on that. So it's on the CFPB.
I think it was emailed around to all the participants, but it's also on our website. And I'm actually, if you'll give me a second, I'm going to scroll down. Well, okay, I'm going to get to it later.
We'll send the link. We'll send the link at the end of it.
It's consumerfinance.gov/mortgage, and then you'll see there's some choices, and I forgot what the link is, but it's like helping borrowers or something like that. And I have a picture of it at the end of the slideshow here. And my email's also, you know, if anybody is having trouble finding it, you can always email me or call me, and it's Kathy, CATHY.Mansfield@cfpb.gov.
So,
we're getting the link there, yeah, hang on. Oh yeah, here's the landing page when you go to consumerfinance.gov, and it's this link right here, Understanding Our Mortgage Rules.
Good. Let's go to some other questions. So we have had several people who have asked variations on this theme, but what if a borrower has been given a trial mod and made 2 payments, and the loan servicing has been sold to another servicer, and neither entity is accepting the payment for the 3rd trial mod? And there was a similar one where somebody had been given a mod offer, but the servicing had been sold, and they can't get somebody to deal with them about signing the offer.
So it's someone who's already gotten a modification and a new servicer won't honor it.
So number 1 is the trial mod is in place and they've made some payments. The second one, they've had a trial mod offer, but it's not been completed.
So I'm going to let Odette take the first one. The second one is if an offer is made and servicing transfers, the rules say that the new servicer basically has to pick up the baton where the old servicer left it, as long as that would have been a complete application for that borrower. I'm sorry, for the transferring servicer. So the new servicer should, under the rules, just pick up where the old servicer left off. Odette, do you want to comment on the first and maybe the second as well?
And I'm sorry, absolutely the new servicer under the rules should pick up. And I'm sorry, the variation with the first one was that they were already under a mod?
Yes. They'd made a trial too. They'd made 2 trial payments. We're due for the 3rd, and neither servicer is accepting the 3rd payment.
The new servicer absolutely should be accepting that payment. There are other provisions of RESPA which require that servicer, when they take over the servicing, if there's any existing loss mitigation plan in place, they have to honor it as well.
And any suggestions about what the counselor should do in each of these situations to, given that they're both on the hook without being able to get a resolution from the servicer?
Kathy, were you going to talk about the CFPB model?
Yes. Yeah, and I was going to talk about this later, but if you are having trouble, there's a couple things you can do as far as letting us know. One is that we have, and I'm going to go back down to the end of the presentation, but we have a group called Consumer Response, and that's meant to be complaints by individual consumers. So if you're helping an individual consumer and you're having trouble for that individual consumer, you can file a complaint with Consumer Response. And there's our consumer complaint portal. That's what it looks like if you go to our webpage. And you can file a complaint on behalf of the consumer, or they can file a complaint. And then our consumer response team will basically work to try and resolve the issue. If it's a more systemic problem, like you're seeing a particular servicer refusing to honor modifications that are completed, or any other sort of systemic problem that you're seeing, we will eventually have some sort of line set up that will go to our enforcement division. So we have, the CFPB has 2 ways of enforcing these rules. One is through enforcement actions against servicers, and the other is that we'll be auditing servicers for compliance. And so we know that housing counselors and the like are, you know, kind of the boots on the ground first people who are going to see a systemic problem. We don't have that portal set up yet, so in the interim, we're just asking people to email me, and I'm forwarding it to the right people. I'm really hoping that we'll get that set up really soon. But in the meantime, again, if you're seeing something systemic, a particular servicer not complying on a regular basis, please let me know and I will forward it to our enforcement division.
Kathy, I want to add that in 2012, 5 of the biggest servicers, if the servicers that you're complaining about are one of the big 5 that were covered by the National Mortgage Settlement, which include Bank of America, JP Morgan Chase, Wells Fargo, et cetera. Part of the settlement does explicitly address this issue, and you should not only complain to the CFPB, but also to your state AG's office, because they were the ones that signed on to that settlement, and also to the Office of Mortgage Settlement Oversight.
Absolutely. And you may consider, you know, complaining to your state AG as well. You may consider, you know, complaining to the FDIC. There's other entities, but we definitely want to make sure that we hear about it as well.
And I hope we'll talk about this a little bit later, but there's the checklist that NCLC and HRC are doing for the AG settlement that would allow you to submit complaints to the CFPB, UMSO, and the AG. So another question that came up. Go ahead.
No, I'm sorry. Go ahead.
Yeah, another question that's come up from several people is where homeowner has not received monthly statements in quite some time, in one case 2 years, does that mean now that the servicer will be required to start sending statements out in February?
Yep. That's an easy one, and the answer is yes. There are some exceptions to the rule. It's possible that the consumer might get a payment coupon book or something in place, but they should start getting a periodic statement. If their mortgage payment is due on the 1st, then February 1st would be the first time they would get that statement. And by the way, we have other material on our mortgage landing page, and I'm going to go back up to that. But if you go to Help for Homeowners, we have things like an example of what a periodic statement looks like under the new rule and what it looks like if there's a delinquency and that sort of stuff.
I would very much encourage counselors to take a look at the statement that outlines what the delinquency is. It's very useful for you in terms of trying to look at where the homeowner is, how much they owe, and going forward, what kind of workout would work for them.
And again, this is one that they should send to the CFPB if it doesn't surface in February. Is February the magic date at this point? So
it's whatever the first periodic payment date is. So I think a lot of people's mortgage payments are due on the 1st of the month, but that's not necessarily so. So you know, if someone has a mortgage payment that's due on the 20th of the month, they should have gotten a statement on January 20th. So if it's 1 through 10. You'll see it in February. And if it was 11 through whatever, you should have seen it already in January.
Okay.
Well, I guess not. What's today, the 28th? So.
Do the rules apply to reverse mortgages?
I don't believe so. Odette, do you know the answer to that one?
Yeah, there is an exception for reverse mortgages, yes, because they work differently than forward mortgages. So most of the rules most of them do not apply to reverse mortgages. There are some exceptions, but most don't.
So is a client file considered received by the servicer when it's uploaded by the counselor through Home Loan Port, or when it's actually opened by the servicer, and there could be a gap of some time between the two?
In terms of starting the clock running?
Right.
Okay, I'm going to look up the exact wording of that rule. And Odette, do you want to answer it while I look up the exact wording?
Yeah.
I know what my gut answer is.
I know the rule says received, but I don't recall if the rule defines what received means.
I don't think it does.
I don't know. I don't think it does either. I don't recall that it does.
Yeah, I don't think it does either. But, you know, again, this is why those general good guy rules are so important, the 102.4.38. If you have a servicer who's regularly claiming that they're receiving documentation 60 days after you upload it, we would definitely want to know about that.
My understanding go ahead.
No, go ahead.
No, I think my understanding of some of these, and Bruce, correct me if I'm wrong, some of these electronic systems is that you are able to, once the document is uploaded, at least have that date and time when it was uploaded, even if technically you don't know under the rule whether it's considered received or not. And I would, you know, as an advocacy strategy, I would say, hey, it's uploaded, that's the date that it's considered received, but I don't think it's clear under the rule.
Especially because if it's deemed to be received at a later date, it may completely affect the borrower's rights. In other words, it may be that may put you in the period between 45 and 37 days before a foreclosure sale, or even worse, it might put you in the period closer to the foreclosure sale than 37 days.
Okay, another question. So a counselor asked, how do we know if the servicer is considering the application to be complete?
As long as the application is sent in more than 45 days before a foreclosure sale, you will get that letter from the servicer that tells you, it's required to tell you if the application is complete or not, and if it's incomplete, what needs to be done to complete it.
And we have an example of somebody who submitted a package on the 13th. It has already been denied. There was no explanation for the denial. And
this is of January?
Yeah, January, yes. And I mean, they also said it was in a case in mediation. So, but the question is sort of, what do they do now?
So the application was completed before January 10th, but it was denied after January 10th.
It was submitted after on the 13th.
Oh, the application was submitted on the 13th, and it's already been denied.
Right.
I think I'm going to let you take that one, Odette.
Well, they're supposed to get a notice of some sort, a notice of decision, right? And so what we're saying is that they haven't received this notice, which is clearly a violation of one of the loss mitigation rules. So I would absolutely, escalate that, not only with the CFPB, but with the AGs or any other manner that you in-house with all the regulators to get a clear resolution for that.
And that may be a time to look to an attorney as well.
Right, of course.
And again, when the servicer denies well, okay, I guess we have to back up. If it was a denial of a loss mitigation, that's one thing in terms of an appeal or other, but if there should be a reason for the denial that's specific. And so just a general denial doesn't cut it.
Exactly. So folks, you're looking to your homeowner to provide you with a couple pieces of paper if those papers aren't coming to you. That's that pre-foreclosure notice that Kathy mentioned. There's that acknowledgement, which will tell you whether the application is complete or not complete. That's gold. You should really make sure you get that. If the application has been filed, there's a notice of decision with specificity as to if there's a loan mod denied, specificity as to why that loan mod was denied. If there's an appeals process, I don't think you've touched this yet, Kathy, but there should be a notice of decision after that as well.
So I have so let me just read a question quickly that just jumped on me, but here we go. When a trial and or permanent modification award letter is sent, you stated that the homeowner has either 7 or 14 days to accept offer. Does that take into account the days it takes to be received in the mail, which given the 7-day option can use 3 to 5 days to be received by the homeowner?
Sorry, could you read that slower?
Okay.
I'm sorry.
When a trial and or permanent modification award letter is sent, you stated that the homeowner has either 7 or 14 days to accept the offer. Does that take into account the days it takes to be received in the mail, which given the 7-day option can use 3 to 5 days received? Okay,
so first of all, it's important to note that that's the minimum number of days that the servicer can give the borrower to accept or reject. So it's not necessarily going to be 7 days and not necessarily going to be 14 days. That's the minimum. The rule does not, so the time starts running from the time the servicer provides the borrower with the offer, and the rule does not define provide. So that's all the guidance I'm afraid I can give on that. Odette, maybe you can expound on that a little.
Yes, you're right, Kathy. That is the minimum. Under some other guidelines, National Mortgage Settlement, which is one I just trained on, it's you get more days. So it's there are guidance in the rules that say that they have to mail it by first-class mail. So it doesn't say how long that should take, but whatever length of time first-class mail takes is probably included in, added to the days that are required, the minimum number of days that are required to be provided.
And somebody just asked if they're calendar days or business days.
It depends on the rule, and I have to look at the rule on this particular one to see if it's calendar or business. It may not, actually it probably doesn't say. So where it doesn't say, I'm sorry, go ahead.
Oh, no, go ahead, Kathy, because I think most of the rules, you're right, it depends on the rules, but most of them.
I think most of the rule is calendar unless it says it's business. So this rule doesn't say, which would mean I would think it was calendar. But I want to make a broader point, which is, again, there's that general 102.4.38 set of guidelines. And if you see a servicer who you think is sort of gaming the rules in order to deny borrowers their rights, that may be a problem under the policies and procedures section in 102.4.38. And so that's still something that we want to hear about.
So why don't we keep going with the rest of the presentation because we're running out of time. We might go over time a little bit. I hope that's okay with you.
Well, and I think we can. I think I'm going to just sort of go very quickly over what's left without even using the slides. Or maybe I'll go back to the slides. So it seemed important to us that we've just talked about the rights and contacts that borrowers who are delinquent are going to get from their servicer, or even borrowers who are afraid they're going to become delinquent. But sometimes a borrower is not, in fact, delinquent, and they are just considered delinquent because the servicer has done something that kind of messes up the payment history. So the rest of the guide up until the last section deals with that. So I'm just really quickly going to go through this. So first of all, the guide talks about full, you know what, I am not going to use the slides because I'll end up just reading them. The guide talks about processing full and periodic mortgage payments. Basically full periodic mortgage payments have to be credited as of the day that they're received. And if they're credited later than that, that's okay as long as it doesn't reflect badly on the borrower. In other words, they can't have fees, they can't be reported to a credit reporting agency, et cetera. There are rules on partial periodic mortgage payments. Basically, the servicer can decide whether or not to credit that on receipt, return it to the borrower, or put it in a suspense account. But there's rules on what they have to tell the borrower if they put it in a suspense account and what they have to do once there's a full payment. There's a provision on limitations on pyramiding late fees. So in other words, you can't have a borrower who's chronically delinquent because any payments they make are being applied backwards to late fees. There are very strict rules on force-placed insurance. Generally, and this is a big part of the guide, but generally, in order for a servicer to purchase force-placed insurance, they have to give 2 notices to the borrower. One's at 30 days and one's at 45 days. The notices are very detailed. They require that the servicer ask for proof of insurance from the borrower, as well as a whole bunch of other stuff. The servicer cannot purchase the force-placed insurance during that time period, and if the borrower proves they have insurance. And then if the insurance is purchased, it has to be bona fide and reasonable. So that's dealt with in the guide as well on pages 56 through 71. And then the last 2 parts of the guide deal with error resolution and requests for information. And Odette, do you maybe want to talk about error resolution and then maybe get to your slides that are on the back here?
Sure, Kathy. So error resolution. So one of the really great tools that we have under RESPA is a qualified written request. And it is simply that, which is a homeowner or you as their counselor will draft a letter to the servicer asking either for information or to correct errors. In the new rules, they break it down into 2 separate procedures, but it's similar to what was there before. The error resolution procedures are particularly great in terms of helping homeowners who are not getting the protections that they need under the rules. Simply what the homeowner has to do is to write a notice, but it could be just a letter, making sure, asking or telling the servicer that there's been an error on their account and that they need to resolve that error. And what the servicer is supposed to do once they receive that letter or written notice is to acknowledge receiving it within 5 days, 5 business days, so it excludes weekends and holidays. And then they're supposed to take steps either to correct the error right away, right, and let the homeowner know, or to investigate or conduct a reasonable investigation. And if, for example, they investigate and they figure that there is no error, they certainly have to let the homeowner know that, and also tell them or give them the opportunity to request the documents or information that they relied on to make that determination. And I'm going to stay on the error resolution for a minute because I want to give you a sense of what in the rules they give you as examples of errors that you can challenge. Certainly if your client sends a payment and it's not credited properly, that's an example. If they didn't pay out of escrow properly, if they impose a fee or charge on the account, that's another example. So the rule goes over really provides 10 examples, and also at the end has a catch-all provision. If it's not listed in the rule, any other error that that comes up on the account, you can use this process to challenge. 2 of the key errors that you can challenge, and this is really important, is when the servicer starts the foreclosure process. Remember, Kathy went over how that happens, you know, with the 120 days, pre-120 days, post-120 days, and the restrictions, the dual process tracking restrictions. If they start the process against the rules, in violation of the rules, you can send that letter to the servicer saying, hey, you started this in violations of the rules, we submitted an application, we did not receive a notice of decision, we have no idea, and then you started the whole process. That's a great way to challenge the servicing under this. That's a great way to force the servicer to go back and correct the whatever the error was. And in this case, it was starting the process. So what that means is that they would have to cancel or postpone that foreclosure sale if it's already been scheduled.
And could I just add that
sure,
the guide has all the details about that in it with cites to the regulation, and when you send an error resolution notice, I would recommend citing to the regulation so that it's clear you're sending an error resolution notice as opposed to an information request. And that's because the error resolution notice rules say that the servicer cannot report the borrower as delinquent to a credit reporting agency while the error is being investigated. And the borrower does not get the same protection under the information request rules.
Absolutely, Kathy. And I was going to turn to the information request rule and say that the time period of the guidelines and the requirements are very, very similar. And certainly you can combine the information request and the error resolution notice in one, but I would as well suggest that you break it down and send 2 separate letters as well. But again, the information request, a great way if all the documents that you have in your file and you're still sort of figuring out what's going on with this loan account, you can request a complete loan transactional history through that process. So it's a really great way to get information and insights into what's happening with your clients, the servicing of your client's loan. That said, on your screen you see a new copy of NCLC's latest book, Foreclosure Prevention Counseling. There are sample letters that you can use and refer to and give your clients. So sample notice of error, sample information request in that book as well, and that's the newest edition. And also another key tool that we've developed along with National Housing Resource Center is a checklist. It's an online complaint tool that we have designed for housing counselors to help you to escalate cases with the AG and the CFPB. Now, this checklist refers to the National Mortgage Settlement, which is the servicing standards under that particular settlement, but they are very similar. to the CFPB rules. And in fact, in the back of our book and online at NCLC's website, we have a chart which outlines the CFPB's mortgage rules and compare them next to the National Mortgage Settlement requirements that the Big Five servicers are required to use. The checklist is pretty intuitive. You can complain about one case, or you can upload complaints about multiple cases at one time. And you simply check off what the problem is from a list of 18 common errors. And then if we could stay on this page for a minute, I want to make sure people realize that after you have submitted the complaint in our checklist, you can then simply go to the CFPB's website and complete their complaint form, as well as go to your State Attorney General's website and do the same. So it's a one-stop shop. You can complain to your state AG and the CFPB at the same time, and those forms, once you go to the AG's website or the CFPB's website, will be auto-filled. Most of the information, or some of the information that you provided to us, will be auto-filled into those complaint forms. And if you could just go to the last slide, please. So one of the things that we provide as part of the checklist is a summary of everything that you included or everything that you complained about. It will be emailed to you. You can copy and print that and keep that in your file. You can certainly copy and paste, and when you go, if there are further developments in the file, you can add to the summary so that later on, if you need to send it to another agency or somehow escalate in-house or for other purposes, you have a sort of a nice capsule, a nice summary of what the various servicing violations were with your client's case. So that's just one tool that we've made available to you that we hope that you will take advantage of, and that will streamline your process for escalating some of these servicing-related issues. And Kathy?
Yeah, so we were kind of at time. I don't know if you want to take some more questions or...
Sure. Kathy, if you're willing, I'm willing.
I'm willing.
So the first thing on the list was that a couple people asked for monthly webinars like this, so I don't know if maybe we can do some follow-up too, and with more time to ask questions, that might be helpful.
Yeah.
What happens if a client is waiting for a subordination agreement and it takes longer than what the servicer investor time allowed?
I don't know the answer to that. Odette?
Yeah, I'm sorry. So a subordination agreement, and it goes outside the scope of what the
well, no, but
is this like on a short sale, or what are we?
Well,
yeah,
we don't know, but
in what context?
We don't know. I mean, what it says. So it's a question of if that's the reason for the delay in the process, so that you run out of your deadlines in the foreclosure process. Should I read the question again? I mean, subordinations
No, because I think we
time.
both need definition of, like, what's the subordination agreement for?
Right. I mean, there's some parts of the rules that allow for a little leeway, like in the notice, in some responses to the notice of information or notice of error, but it's very limited. It's very, very limited. The rules are the time frame.
And it's basically the servicer's responsibility to gather within their deadline the information they need from outside parties to do a complete evaluation. So it's just, I'm not exactly sure what we're referring to here, whether this is like, if it's a short sale, that's a slightly different thing. But if
they added a little bit of information, a modification agreement - lien that they are working on getting released. So it's a modification agreement, and they're working on getting a lien released.
Getting like a subordinated lien released.
Yeah.
Like my guess is this is an existing second or third mortgage that's going to be released as part of the modification. So I'm gonna go with that. And you know, I would say at that point, you know, basically the servicer's done evaluating the borrower, and they're basically saying that they're going to give a modification if they can get that lien released. So it seems to me then you're executing the plan under a loss mitigation plan as opposed to still in the evaluation process. And of course, the rules focus on the evaluation process. I'm not positive that's the correct answer, but that's my best guess.
Yeah, I would say the same, Kathy. Although, even though the CFPB rules may not apply, there may be, depending if it's Fannie, Freddie, there may be other rules that apply that the investor, insurer, or owner will impose. So, but I would agree.
So somebody has asked if somebody's been wrongfully denied under the new CFPB regs, would they have to get a new loss bit package submitted to take advantage of the new rules?
If they've been wrongfully denied under, say that again, under?
Well, so presumably they've been wrongfully denied. So
before the new rules.
Right.
So if they've been denied prior to January 10th, or they were in the middle of an evaluation on January 10th, they're entitled to reapply. So that borrower definitely, might benefit from an evaluation under the new rules. If someone's been wrongfully denied, then that's something that the CFPB would need to hear about. But if you're talking about like the process for a denial, like the servicer didn't wait the requisite number of days before starting a foreclosure, or they didn't get all the information, they evaluated an incomplete application, or that sort of thing, those are things that our rules address. If they were denied something they were entitled to, and the servicer sent a letter saying you're being denied because of this specific requirement, and they've misapplied the requirements, then that's a time to appeal. But our rules don't actually tell servicers which packages they have to grant or not grant.
Yeah, absolutely. The option that's offered to the homeowner is still at the discretion of the servicer.
So here's a couple questions built into this one. How do you find the regulatory agency that oversees a servicer? But the second part of it, I think, is probably the driving force here. We have a lot of new second-tier servicers where the information on the website is limited.
The information on the servicer's website is limited in terms of finding out what programs are available. I assume that's what this person
or maybe
is
contact
talking about.
information, escalation information, those sorts of things. That might be a problem as well.
So, I think the answer to that is under the new rules, housing counselors shouldn't have to be the ones who are proactively seeking out the servicer, because the servicer is required to proactively seek out the borrower. So you should be getting borrowers in your offices who have their 36-day post-contact, the letter that's supposed to come after the initial oral contact, and they should have the 45-day notice, and they should have a periodic statement, their most recent periodic statement. That should make it easier to find and contact the servicer, because the whole point of those early parts of the rules is to start that conversation between the borrower and the borrower's agents, including a housing counselor, and the servicer. In terms of finding out what substantively is available, the rules don't say that servicers have to make that information available specifically on a website or anything like that. But if you look through the guide and through the rules, you'll see that servicers do have to provide first general information and then more specific information about what's available for borrowers. Odette, do you have something to add there?
To get around some of the misinformation, it helps to figure out whether the loan, the investor, or the insurer on the loan is, because that also drives what information or what options the servicer is going to provide. So, for example, if it's an FHA loan, the FHA has a package of workout options that the servicers are required to offer the homeowner.
Here's another question. I submitted to Greentree at the address on the MHA.gov site, since their listed fax machine doesn't answer, and they are not part of Hope Loanport. I have followed up with a single point of contact, and all I ever get is voicemail. client and I have not had written contact from the lender, such as a 10-day letter / 30-day letter or additional info letters. Any other way to get a response from this lender?
Is this Green Tree servicing their own loan, or are they servicing someone else's loan? Do we know? Is there a way to
It doesn't
ask
say,
that?
though. I'm not aware of Green Tree owning loans, so let's assume that they're servicing someone else's.
That they're servicing. You know, I'm going to ask that person to maybe email me directly, and maybe we could set up a time to talk about that particular case. So my
That
email's
sounds
up on the,
Yeah.
that's me, the third one. So,
So Kathy Mansfield at CFPB.
I mean, the general answer is if they're not complying with the rules, then we need to hear about that, and you're entitled to demand that they comply with the rules. But I have a feeling I need to know more about the specifics.
Okay. Good. Well, I think that might be it on the questions. That we're running out of time here. So I think this has been a terrific presentation. Thank you so much to both to Kathy and Odette, and to Nancy and everybody who's participated.
Thanks for hosting this.
Thank you.
It's our pleasure. All right, thank you very much.
Okay.
Great.
Thank you, guys. We'll follow up with email. Take care.